Yo, JPZ. I'm going to talk today about, wait for it, asset purchase agreements and why you need litigation counsel to vet deals. Okay? Wild, right? Wild. Now, maybe this is not your wheelhouse, okay? Maybe you only watch my YouTube videos to learn about employment law, non-compete, discrimination, whatever, okay? That's fine, all right? You can watch this or not. Maybe you'll get something from it. Maybe you won't, but this is part of what I do. I'm JP. It's the JP show. I only talk about what I know, and I know some things about this topic right here. So I'm just going to spit on this, okay? Anytime that you are involved in the purchase or sale of a business, okay? And remember, folks, a lot of people, they can't quite understand, like, yes, we represent hundreds of individual employees. We do lots of plaintiff side employment cases, discrimination, wrongful termination, sexual harassment, etc. We do the non-compete and trade secret defense cases, okay? And we do it for individuals, but we also get involved in like very high stakes, high dollar, sophisticated, commercial litigation involving non-compete, trade secrets, partnership breakups, etc. And so one of the things I have seen time and time again over the past 15 years is business transactions, primarily the sale of a business or an asset purchase agreement, where stuff goes south and there's litigation, often over millions, if not billions of dollars, literally with a B, okay? And that entire problem, dumpster fire, train wreck can be traced back to the fact that the lawyers who wrote and approved and signed off on the APA didn't know what the fuck they were doing, okay? Sorry, that's not folksy and old-timey and collegial enough for you, okay? That's the real, right? And that's what I'm about, is about the real, okay? Many years ago, when I first started my career in law, I worked at a big firm. I worked at a firm called Boyce, Schiller, and Flexner of David Boyce fame, okay? And one of the first cases I got assigned to work on was Lehman Brothers and Barclays, okay? So during the financial crisis, you go back 2008, Lehman Brothers goes belly up. They put all their assets up for sale. It's a fire sale. The economy is crashing. This is like historic devastation in the stock market, okay? The Great Recession. There are no buyers that can do this, but Barclays shows up and is like, we'll buy all this stuff. These assets, we'll buy it. Billions, we'll buy it. We'll pay these billions, we'll get these assets, give them to us, okay? So it's a fire sale. And it is very tenuous, uncertain times, okay? Tremendous risk out there. Barclays took on tremendous risk in buying these assets in a very uncertain market, okay? Not really clear, a lot of opaqueness, not really clear exactly what all the assets were. But it's like, hey, we have these different buckets of securities and assets. And Barclays is like, buy them all. Here you go, billions, give them to us, right? And we'll figure this out. We'll make money off of them. So we get past 2008, okay, the market tanks, and sort of, it's like, okay, it's clear that like we're going to survive. The economy is going to survive. It'll eventually come back, etc. Like, yes, it's going to be ugly. It's going to be tough times, but like, it's like the George Bush sort of Fed meeting, where I forget who it was, where the quote was attributed to them, basically saying this whole thing is going to go down the shitter, right? That's not my quote, that's theirs, right? But that's where it was. And we came out of that. And so Barclays had purchased substantially all of Lehman Brothers assets in a bankruptcy sale, which is called a 363 sale, okay? Know a little bit about bankruptcy law too, right? Not just from the Barclays Lehman Brothers, but also from going into bankruptcy, coming out of bankruptcy, taking stuff into bankruptcy to like get out of Dodge in a state court, right? Like we know how to cook. We know how to cook. But so after the sort of crisis, okay, emerged, it became clear that Barclays had made a really savvy move and a really good deal, okay? Like they took a tremendous amount of risk, but there was a lot of upside there, okay? And so what did Lehman Brothers do? Lehman Brothers turned around and said, wait a second, hold the phone, okay? We want to undo this deal, right? There was a fire sale. We sold all or substantially all of our assets to Barclays for billions of dollars in the middle of the financial crisis. But we didn't know what we were selling. They tricked us. They tricked us. We sold them these assets, but we didn't know what those assets were. And those assets are worth too much money, and Barclays got too good of a deal. And now we want to unwind this whole thing, okay? To the day, right? Under the bankruptcy code and under the bankruptcy equivalent of Rule 60B, Federal Rule 60B is the rule for relief from judgment. And there are several different grounds upon which you can subsequently move after a judgment or after an order. And you can say this order or judgment should be set aside and the case reopened because of X. And sometimes it is a mistake, it is fraud, it's a change in the law, or it is the grand reservoir of justice. That's like 60B6, right? That's like got 60B1, 60B2, right? It's a little bit complicated, right? But there's all these different grounds that the rule lays out, and the federal rules and the bankruptcy code has a similar analogous rule, but only under the bankruptcy rule. And so Lehman Brothers moved to set aside the sale, okay? And basically said they have to give us more money. We sold these assets for X, but we subsequently realized we didn't know what we were selling because Barclays tricked us and we want more money for this, okay? Lehman Brothers lost, okay? Like they tried that, they lost. Barclays won, rightfully so, kicked the snot out of them, okay? Because how are you gonna sell basically all of your assets and then turn around and say we sold it in a crisis and fire sale, but we got tricked because we didn't really know what we were selling? You know what's so funny, okay? In that case, and just you look at I worked on the case, okay, when I was at Boyce Schiller, but you just look at the publicly available record and dockets there. It's in the papers that are publicly filed. Lehman Brothers had a team of big firm lawyers. I mean, we're talking, my God, they're 10, 15 lawyers, right, working on this huge deal, billing several $100s an hour around the clock to put this together, okay? What do you mean you didn't know you were selling X assets? What do you mean you didn't know what assets were in there, okay? What do you mean you're going to turn around a year later and say they tricked us, they got too good of a deal when they bought our stuff because we didn't know what the stuff was? But you see this kind of thing all the time, okay? Not in the financial crisis, not to that magnitude because it was billions with a B, but you see that type of situation all the time where there's an asset purchase agreement, there's a business sale, there's a transfer of assets. You got a whole bunch of deal lawyers working on the transaction. The transaction goes through, everything gets signed off on. Fast forward 6 months, a year, 2 years, and then shit hits the fan. And in most of these instances, the people who are in the disadvantageous position, okay? The people who are looking at it and being like, well, this is screwed. What the heck? We got a bad deal. What are we going to do? And then they get into it, right? So get into litigation or what have you, and they get their ass handed to them and they lose, right? They lose. they're always throwing up their hands and they're always saying the same thing. They're always saying, we had all these lawyers, okay? We had all these lawyers who put together the deal. They wrote the agreement. They wrote the APA. They reviewed it. They signed off on it. They told us to sign off on it. I've had so many situations, okay? Like, yes, we've litigated business sale cases, okay? We've resolved business sale disputes. We advise on those types of things all the time. But I've seen it countless times where somebody comes to me and they basically say, I bought this business, I bought these assets, or I sold this business, I sold these assets. Now, X problem is happening, and I went to the contract or the APA, and I don't understand because my lawyers worked on this. I had, 3 or 4 transactional lawyers from a big firm that charged, a percentage of the deal or $1,500 an hour or whatever nonsense. And now, 6 months later, a year later, 2 years later, the deal's done. It's been closed. The deal lawyers have been paid. They're out of the picture. And I'm looking at this and I'm like, this isn't good. This is a problem. I think I'm fucked. I go back to the deal lawyers and they're like, yeah, we don't know what to tell you. We don't know what to tell you. And the person is screwed. Often to the tune of many millions of dollars. I've had situations like this where I've, done consulting and advising, where people have been screwed to the tune of $15, $20 million, all because they did a major business transaction, purchase or sale of assets, APA, and they relied on deal lawyers, transactional lawyers, okay? There are certain transactional lawyers who are really good at what they're doing, okay? They really know their stuff. But I find that the really good transactional lawyers have a very solid knowledge and understanding of litigation and of what happens in these situations and deals where things go south, shit hits the fan, there's litigation, there's arbitration, there's a dispute, because you can't properly structure deals and vet deals and vet the terms and sign off on the contract unless you've actually litigated a bunch of those cases and seen dozens of different situations and scenarios and choose your own adventures. And so the point is that when you're involved in a transaction, especially the higher the stakes, the bigger the magnitude of the transaction, the more sophisticated, the more money at issue, the more you need to vet that deal and that contract through the lens of potential future litigation. And I'm sorry to say it, I'm sorry to be the bald-headed jerk-faced meanie that I am and the bearer of what may seem like bad news. But there are a whole lot of transactional lawyers out there running around, even ones at big firms, even ones who charge a percentage of the deal or $1,500 or $2,000 an hour. There are a whole lot of these folks who have zero understanding of the practical, real world consequences of what they put on paper in terms of a contract or an APA. Okay? There are a whole lot of these lawyers who that's it and that's all they're doing. All right? They're just putting it on paper. Okay? They have zero comprehension of what it really means or where it really goes. Like, they know what the words mean, okay? They know what the words mean on paper, and often their APAs, their contracts, their terminology, it's a bunch of legal jargon and gobbledygook, right? There'll be a paragraph that's like that long when it should be like 2 sentences. Instead, it'll be like 7 sentences long, whole bunch of legalese, a bunch of gobbledygook when it should be 2 sentences, right? They think it's crafty, you know? They think it makes it look more sophisticated, throw in all the bells and whistles, use all the right buzzwords and jargon, make it look complicated, make people feel like, man, we must be getting like what we're paying for, because there's a lot of law in that agreement, a lot of words in that contract, must be getting what we paid for. When I represent like executives, I've represented lots of executives, including publicly traded company I'm talking CEO, COO, CFO. When I represent these folks in like negotiating their exit from one company, their package or sign on at another company, the engagement letter for that is 1 page long. 1 page. Doesn't even take up the full page. It says basically, here's what I'm going to do. Here's the base fee. We agree to both, act in good faith and be reasonable here. If we need to have a fee beyond this, but like, we're going to use our best efforts. Here we go. Right? Not even a full page, 3/4 of a page, including the signature blocks. But so much of law and sort of the old-timey muckety-muck way of doing law, which I stand against and am attempting to tear down actively and openly and notoriously, goes in that direction, right? More words, more legalese, more jargon, more gobbledygook. Make it look the part. Then you can bill more for it and say, see, you got all of this, right? And in deals and APAs, I see that approach. I see it go south all the time. And a lot of the lawyers who write those deals or broker those deals, they don't have a sufficient litigation skill set to vet the deal. And or they are so invested in getting the deal through because they're going to get paid for it and paid on it and paid out of it, that they're not going to tell the client, this is a fucking problem. They're not going to tell the client, this is a no-go. Can't do this. This is an issue. This is going to come back to bite us. We can't sign off on this. We need different language. They're not going to do it. They're not going to do it. Don't push it through. Push it through and get paid. So, were I buying a business, selling a business, doing a major business transaction, sure, you have your transactional deal lawyers, okay? But I would also want to bring in, okay, probably a separate law firm to vet the deal from the perspective of shit goes south and there's litigation. And what does that look like? What are the realities? What are our risks? What are our options? What is the strategy? But that's why I'm the chef. Can't nobody cook me. Can't cook me, I'm the chef. Jonathan Pollard, have a great day.